Discover the remarkable story of Dr. Harvey Castro, a first-generation American and the inaugural physician in his family. Renowned as an emergency medicine physician, an acclaimed author of 19 books, and a pioneer in healthcare innovation with a focus on AI and medical technology, Dr. Castro's journey is a testament to ambition, groundbreaking achievements, and a profound commitment to advancing the medical field. Dr. Castro's roots in Queens, New York, laid the foundation for a life characterized by resilience, innovation, and entrepreneurial spirit. Starting from humble beginnings, delivering newspapers, and establishing a vitamin business at 16, his early endeavors highlighted a path of innovation and hard work. Dr. Castro's educational pursuits are as impressive as his professional journey. Alongside degrees in biomedical science and political science from Texas A&M and a doctorate in medicine from UTMB Galveston, he also earned an MBA. As CEO of Medical Intelligence Ops, he seamlessly blends medical expertise with business acumen. In Bethlehem, PA, during his emergency residency, Dr. Castro began authoring books for medical students, leading to his extensive bibliography of 19 books, including groundbreaking works on ChatGPT and healthcare in 2022. In Dallas-Fort Worth, Dr. Castro's career evolved with significant innovations. He developed the world's first IV Meds app, a major leap in medical technology. As a speaker for ACEP and other forums, he has been a guiding force in integrating AI in medicine. Dr. Castro's influence extends globally. He has been a keynote speaker at prestigious events worldwide, from China to Portugal to the USA, including prominent conferences like HIMSS. His insights on AI and healthcare have made him a sought-after consultant for hospitals around the world, helping them navigate the intersection of technology and patient care. He founded trusted medical centers, managing over 7 emergency rooms and a hospital, and his business ventures include staffing companies, a billing company, and a marketing company. In media, Dr. Castro is a familiar face with over 100 live TV appearances and roles as a medical correspondent on major shows. His book, Success Reinvention, and the e-course, AIDE, Artificial Intelligence Decoding and Exploring in Healthcare, reflect his passion for sharing knowledge and guiding others. Beyond his professional life, Dr. Castro is a dedicated family man and an avid learner, always seeking new knowledge in business and self-improvement. Follow Dr. Harvey Castro's inspiring journey on social media platforms. Experience the narrative of a visionary reshaping healthcare and inspiring future generations. In conclusion, Dr. Harvey Castro is not just a medical professional and author. He is a trailblazer in healthcare, a global speaker, a media personality, and a leader in medical innovation. His journey from a determined student to a key figure in medicine is a testament to his dedication, innovation, and enduring commitment to impacting healthcare globally.
All right, welcome. So I'm gonna use AI to introduce our next speaker. And this will only be a couple of minutes. I just love this video that I made for him, so hopefully he enjoys it. So here we start.
Ladies and gentlemen, it is my distinct pleasure to introduce our keynote speaker for today's webinar, Mr. Anthony Tong. As a managing partner at Robin Bridge and John Liu, Mr. Tong brings a wealth of experience and a formidable expertise in the field of intellectual property law. His professional journey is marked by significant contributions in both non-contentious and contentious aspects of intellectual property. In non-contentious realms, Mr. Tong's proficiency extends from strategic trademark filings to patent and product landscaping and IP licensing on a global scale. His innovative approach in devising IP-related joint venture structures and his advisory role in expanding retail chains into the PRC are particularly noteworthy. His insights into copyright law, including the burgeoning field of NFTs, have positioned him as a thought leader in this dynamic area. On the contentious front, Mr. Tong's legal acumen shines through his involvement in legal proceedings across multiple jurisdictions, including Hong Kong, the PRC, and internationally. Notably, he has been the lead counsel in over 80 trademark-related proceedings across 15 European jurisdictions for a Hong Kong-listed company. His strategic leadership was instrumental in defending a significant patent claim at the ITC in the United States and in leading a team to discharge an urgent injunction in Singapore. Mr. Tong's exceptional skills have been recognized by the World Trademark Review, listing him in the gold-tier individuals for both enforcement and litigation and prosecution and strategy in the WTR 1000 for 3 consecutive years. His appointment as a specially appointed mediator for commercial disputes in the Guangdong Greater Bay Area by the Higher People's Court of the Guangdong Province is a testament to his mediation expertise. His commitment to sharing knowledge is evident from his regular speaking engagements and his role as a thought leader, where he offers insights on IP topics to various esteemed institutions. Furthermore, Mr. Tong's dedication extends beyond his professional endeavors. He serves as a member of the Board of Directors of the Hong Kong Applied Science and Technology Institute, ASTRI, and has contributed as the ex-deputy chairman of the Copyright Tribunal of the Hong Kong SAR. We are indeed privileged to have Mr. Tong share his unparalleled expertise with us today. Please join me in warmly welcoming Mr. Anthony Tong to our webinar. This introduction aims to smoothly transition between various aspects of Mr. Tong's career, highlighting his achievements and roles. Using a structured format, it encapsulates his professional journey, with a focus on both his technical expertise and his contributions to the broader intellectual property community.
All right. Well, welcome, my friend. I'm going to step down and let him control the PowerPoint and all that. So thank you so much. I know it's really late out in China, so I really appreciate your time.
Not at all, Harvey. Thanks so much. I'm humbled and speechless by the introduction of myself, which reminds me of one of the issues I'm going to talk about, which is hallucination in AI-generated work. But I won't tell you which bit is hallucination, which bit is true. But anyway, thanks for helping me, for having me today. And I'm so excited to be here today with all of you. I am a practicing solicitor in Hong Kong, so maybe a bit of a distance from most of you where you come from. So today I'll be talking about the latest developments and legal challenges in artificial intelligence globally. But of course, as you've heard, I'm only a humble practicing lawyer in Hong Kong. So I'll try my best to let you know what I've gathered from all the materials that I've come across. So without further ado, I will get started right away. Okay, I have to use, okay. So I will skip the part about, the usual start as to what is AI or generative AI for that matter, because you can always ask ChatGPT for an answer. Which will be a very, very detailed one. So I don't need to go into that. And I'm sure most of you know about that already. So these are a few of the challenges. There are a raft of challenges out there insofar as AI is concerned. But I've singled these out to cover briefly, to share my thoughts with all of you. I will go straight into it right away. Now, confidentiality, that's probably fairly straightforward. Effectively, for example, if one of your employees should be uploading your customer's confidential information onto a generative AI LLM model, then you will be effectively disclosing confidential information to third parties, and hence probably and potentially in breach of your duty of confidentiality to your clients. So that's the first thing. I will talk about how to mitigate such risk after introduction of these various issues. But this is something that we must be well aware of, and in particular, and which is the most challenging bit. So there's always uncertainty as to how secure the data is being kept by the service provider. We're being just hostage of fortune. We just hope to be lucky that our data or our clients' data will not be misused or disclosed. So on to the next one. And in talking about data protection and privacy, it's important to consider data protection law at all stages of the AI development. In all stages. And I just cited one example of a confirmed data leak by ChatGPT last year, which shows the information, personal information and data of the customers, and some of them have even their credit card particulars disclosed. So these are the risks there. And I want to emphasize is on the purpose limitation. That's very fundamental in any data protection, where, of course, when you secure and obtain the consent of your customers, the data user or of customers, to collect their personal data, there is always a scope, the four corners, within which you are authorized to use the personal data. Now, more likely than not, and if you have not specifically addressed on this point, then it is likely that the customer or patient, for that matter, if you're in the medical field, may not have consented to your using the personal data in the way in uploading them onto generative AI model. Not to mention the purposes of which the generative AI model will be using these personal data. So, and these risks is amplified in cases of sensitive data like personal health conditions. So it's important, because I was talking to a general manager of a private hospital in Hong Kong the other day. They begin to use AI in helping them usually in the radiography sector, in the scanning department, to look at the scan results, whatever, to help them diagnose, which is, of course, much more effective and efficient than human eye. But then the point is, the first thing I commented is you better expand on the scope of consent right away. And do you really want the patient to allow you to keep the data for further analysis for other use? You have to state it as well. So that's important to note. And then, of course, another basic principle of personal data collection, it has to be fair on an informed basis. The customer, the data subject, needs to know. And as we all know, generative AI models employ deep learning technology to analyze and learn from massive amounts of unstructured data without supervision. And they do it, and the developers, they keep their data sets usually proprietary, and they disclose very few details about the collection of data, and this may easily circumvent data protection rules, which require personal data to be collected and in a fair manner. So that's important to bear in mind as well. Okay, the next one. And then, of course, we talk about the output of AI chatbots. The user, as always, might have intentionally be feeding sensitive information to the AI system. And these confirmation will become new training data, or could become. And if such data are being exposed to bad actors, then the information could well have been misused. So, yeah. Now, for retention of personal data, once again, another basic principle, I think that applies internationally, not just Hong Kong or Europe for that matter, is the data subject can request access of the data that's being kept. And talking about the black box approach once again, it will be very difficult if you're being asked to allow access and correction and deletion. So that could be another challenge that we should be well aware of. Now, onto hallucinations of AI, i.e. the generative AI model generates text about seemingly factual claims that are in fact false, and perhaps never even appeared in its training data. The trouble, of course, is in most cases, and on the best part of the output, they are accurate. So you can never tell. Those bits embedded discretely among the output generated is actually false. And of course, we have all this heard about this famous or infamous case of this judge in Manhattan reprimanding two attorneys for submitting briefs to court, which contain 7 citations, which are fabricated by the generative AI model. The judge was particularly displeased when he actually confronted the attorney and say, are these submissions accurate and are the citations genuine? To which the attorney says they are. I've actually asked a generative AI model, and they say this is accurate when they are fabricated. It concerns the a personal injuries claim against, I think it is one of the Colombian airline. And then the 7 cases submitted are all cases filed against various airlines, which doesn't exist. So these are the challenges there. And of course, false claims can hurt people. And then, of course, chatbots are good at mimicking human language, pretending to be authentic. So we have all this challenge there as to how we can identify false information that is intermingled with facts. Now comes the big thing, employment issues of AI-generated works. Now, the use of AI is increasing in employment decisions and in the hiring and recruitment process, and in particular, to automate and thus quicken the process. And this could easily lead to concerns about the potential for AI to perpetrate and amplify biases, resulting in unfair employment decisions. I wonder whether any of you have watched a documentary on Netflix called Coded Bias. It contains some haunting cases where people in the streets in London being pulled over because the AI work has falsely identified someone else to be a suspect or wanted criminal, or in cases in the US concerning the assessment of the performance of teachers for the purpose of laying off some of them. And one of the victims, who has secured and obtained a lot of accolades over the year, was dismissed for that reason. So, and it turns out because of a black box approach, no one really knows how the system works. But the risk is there, so let's look into it. The common applications of AI in employment decisions are these: resume screening, and these are the automated decisions. They just pre-screen an applicant, and it really depends on the underlying data sets. You don't know whether there could be biases or whatever by the AI, and there are various reasons why they are biased, which I will explain. In video interviews where AI can actually analyze your facial expressions and make a prediction as to how well you're going to perform if you are given the job. In the pre-employment assessments, and then there are even cases like AI model can predict how one is going to drive, the manner they're going to drive based on their feedback or comments on social media, whatever, as to whether they like, a bit of a speed, whatever. So these are all the area where there could be bias there. And we have all these human algorithm bias. Effectively, these are personal biases of the individuals gathering the data from machine learning. So it may be done consciously or even subconsciously, but then it could end up being reflected in reinforcing the data collection in the training program, thus the bias. And with the learning bias there, the amplified performance disparities, and we have the data collection bias, which could be historical or representation. So historical simply because of the occurs when the data collected and used to train the algorithm reflects existing biases at the time of data collection. For example, there could be bias. I think there's a case against one of the tech companies, which I won't mention which one, where in the hiring AI model, they rule out, as it transpired, they rule out most of the women applying, because in the tech industry, most of the employees are male. So they just want to increase the efficiency and say more probable than not than a men outperform a woman, which of course I disagree. So these are the bias. And then of course representation bias, when a training data set is not representative of the target population, it can be leaning in favor of one ethnic origin than the other. So these could be issues as well. Now, when it comes to all these issues that we talk about, then we have all these liabilities and who's responsible for what. For the errors generated by AI models. In the Manhattan attorney case, we know the lawyer ending up being responsible, picking up the bill in the end, and they're being fined. Not a huge amount, but the fact that there's a judgment criticizing the attorney, that's more harm than the money involved. So, and of course, if you try to look to the service provider or the developer for indemnity, whatever, for any damage that may have been caused by inaccurate output, then you usually would find disclaimers in the terms of use which you may not be aware of until you want to make a claim. But the truth of the matter is that it's the probabilistic nature of machine learning. So output will never be 100% accurate. That's life. So on the limited side, one can have a little bit of relief when, particularly for those in the creative industry, that there are indemnities being provided by a few service provider, including those I've identified on the PowerPoint, where, of course, I mean, let's be clear, they have varying caps and exceptions. So it doesn't offer blanket indemnity for whatever damage that you have been suffered, or you may be sued for someone and for the IP owners, whatever. But at least there's something that, for example, they are indemnifying you, some of them, against any claim for copyright infringement, which is very important, which I'll look at. So that's important to look out if you want some peace of mind. Then that may be one area to look at. And then on the risk mitigation side, I think I should mention, I think that's important as well. It's important for particularly large organizations to design and put in place an acceptable use policy. And what this policy says, basically, is it is to introduce and impose certain limited prohibitions on the use of confidential information, particularly controls around data protection, as to what an employee can do or not do. For example, I give very strong and strict directive to my colleagues not to upload clients' information onto the internet, onto the AI-generated model for research purpose, because in so doing, you are really opening up and disclosing clients' confidential information. So, and of course, once you have an acceptable use policy in place, you need internal training, which goes side by side. And then you have to train your staff to let them know when they're having an acceptable use policy is useless unless your employees know what the limits are. And you need also to create a risk assessment process. This process needs to be able, this mechanism needs to be able to tell you that once, as soon as a high risk is identified, it will be escalated to a high level for risk oversight, particularly when AI models are routinely used. So that's very important. And likewise, for these acceptable use policy or terms and conditions, your supplier, you may wish to have a look at the acceptable use policy or terms and conditions as well, because if your only employees could be making the same mistakes, then equally the supplier's employees can make the same mistake as well. So these are all the things that you have to be aware of. Plus, you also need ongoing risk mitigation. You need to be aware of regulatory changes because they keep changing all the time. Now, on the international regulatory regimes as of now, in the USA, I do seek your indulgence if I'm not as updated as I should be. But from the last I've read and checked, of course, the US, the administration has issued an executive order on AI on 30th October. And these are very honorable causes and directions. But from what I heard from American attorneys, legal experts, they envisage that it would not be easy for consensus to be reached, for laws to be passed, due to the inherently divisive nature within the House and the Senate. So we shall see. But these are really the right direction. But whether this can be implemented is another matter. And we have in China this generative AI administrative measures published in August 2023, also for very good causes as well, obviously, as always. It talks about content moderation, which basically says that the providers are held accountable as content producers. And then on training data, it requires the providers to source data and foundation models from legitimate source, respecting intellectual property on the way. And then tagging of generated content to ensure that the user knows that what they are seeing and dealing with are AI-generated content. And then there's also a limit on regulation that a user protection, there should be a limit on the amount or not to collect unnecessary personal information and not to store input information usage record. But you need to store them in a way that can be identified. And then, of course, there will also be security assessment and filing. So they must undergo security assessment and algorithm filing. So that's in China. And then EU, in the European Union, it has been envisaging to become a global leader in AI policies. There is a very important agreement reached by policymakers on 8th December. And subject to technical refinements, the AI Act will be passed to the member states for approval. So they're pretty well ahead. One of the important things to note is the extraterritorial approach, just in the same way that the GDPR is phased. Whoever supplying services of AI systems into the EU market will be governed by this AI Act. So it is on a risk-based approach. I won't go into the details, just to say that the risk, basically, there are unacceptable risk. These basically are cognitive behavioral manipulation of people. For example, voice-activated choice that encourage dangerous behavior in children, for example. Social scoring, real-time and remote biometric identification systems. So these are all high risk, unacceptable risk, sorry. High risk, they divide it into two categories, which I've set out below, which I won't go into detail because they can take up days. But this is the first one under new product safety legislation. And these, a few points there, this is for the second category. They're all placed under high risk. And then on the other end of the spectrum, we have the limited risk AI system, where, for example, like AI models like ChatGPT, they will have to comply with the necessary transparency requirements, and tagging, disclosing the content is AI generated, etc. So this is the system, and we shall see how it works once it's been passed by the respective member states. And this is, of course, this wakes everyone up. It definitely wakes me up when I see the hefty fines provided, recommended under the bill. So it has to be respected. Let's put it this way. Okay, and then there is this Bletchley AI Safety Summit. I mention it because it was attended by 29 countries, including, most notably, the US, China, and European Union. So it is representative enough. It concluded with a declaration. Once again, very honorable causes, but I'm not so sure because, of course, in order for the regime to work, you need international harmonization. But given the current geopolitical climate, I'm not so sure that this can be attained. It's a good step forward. We shall see. But this is what has happened. So, okay, let's go on to IP implications, the intellectual property side. Could copyright subsist for a start in AI generative models? If we talk about originality, it requires that the author an expended time, skill, and labor. So, and then who is the author for a start? In Hong Kong, and as I understand it, the UK as well, our respective copyright laws provides that the author for computer-generated work is taken with the person by whom the arrangements necessary for the creation of the work are undertaken. Sounds easy enough, but who are these persons? The AI developer, the service provider, and stroke or the end user. But are they collaborating? Not necessarily, because they are using the AI model at different time and space. It's definitely preceded by the developer, to be followed by the service provider, and then the user are providing prompts into the LLM. So are they really co-authors? Legally, there's some arguments there, but this is the starting point. And then I just mentioned about legitimate author. So in the US, in so far as copyright is concerned, the district court held that human authorship is an essential part of a valid copyright claim. So you need to be human. You can't just say, oh, this is this AI machine that helps me. Well, if they can help you, but you can't say they are the owner. It doesn't work. And then in so far as patent for inventions are concerned, the inventor, that has reached the appellate court in UK for sure. Both, I think US as well, because leave to appeal to Supreme Court has been refused, as far as I can recall, but do correct me if I'm wrong. But the inventor of a patent must be a natural person and cannot be an AI-powered machine. Now, in general, when we talk about generative AI models, whether they violate any IP rights, we usually look at the trinity of three things. The input, where we upload data sets onto the training models. The output, that's when the generative model generates the work that we are looking for. And then we have the defense or exceptions under the law, which I will explain a bit later, that it is pretty fragmented. So, and then, of course, in defense in US, I will talk about the fair use, which has been around since 1975 or 76. And then in other parts of the world, UK, European Union and Hong Kong, we have these permitted acts or exceptions statutorily coded. So it is fairly different. And the on the input side, as you can see, generative AI models are LLMs, large language models trained on huge data sets, which is then improved through the use of human trainers and other forms of feedback. If data sets obtained without a proper license from the copyright owner, then more probable than not, some of the contents used to train these LLMs are protected by copyright, and they're used without the authorization or license from the copyright owner, which is infringement. And in UK and EU, they also have a sui generis database right, where you can't just pick the data and use it. So that's on the input side. On the output, output is, well, generally, copying is restricted under copyright rules. I think that's self-explanatory. But are we talking about output being simply statistical approximation based on the data sets? Or is it a substantial reproduction of the underlying unauthorized copyright works used to train the model? We'll see in some cases, this is definitely the plaintiff's case, that, well, it's not just statistical approximation, it is 100% copying, because we can manage to find identical works being generated or regurgitated from an AI, generative AI model. So that's the output. And then let's talk about the recent US, UK cases on AI. The first one, McCann and others against Stability AI for using the stable diffusion model. This is one of the first cases. There are currently about a dozen US big AI cases ongoing. And there are some preliminary decisions, but there's no trial decisions as yet. It doesn't really matter anyway, because for a case to, from start to end, including all the way possibly up to the Court of Appeal, up to the Supreme Court, it can take 10 years. Like the Google case I mentioned about, it's taken 10 years. And for another case, the VCR, the Betamax VCR, I wonder whether any of you still remember this video cassette recorder or whatever, where it allows users to record TV programs. And I think it's Universal Studio that brought proceedings against Sony Corporation. And it took 9 years for it to all the way go to the Supreme Court. And by the time the case is heard, almost everyone has already owned a video VCR machine. So it's quite funny. But anyway, back to McCann. These visual artists, they make a living, of course, designing visual arts. Some of them designing the outfits of movie stars in a lot of movies as well. So they say it is their case that Stability AI simply uploaded all of their works, catalog them, give them captions, and then if you want something similar with a similar vibe of a certain artist, you just key in the name of the artist plus a certain style that you would like it and press a button, and then there you go, you have a piece of work that resembles the artist. So the plaintiff's case goes. The defendant, Stability AI, brought application to strike out dismiss some of the claim, and for now, insofar as the output bit of the case is concerned, that has been struck out. But the point about the input, about uploading these visual artists' works, whether that constitutes infringement, that's still ongoing. And plus, the plaintiff is allowed to amend the claim to see whether they can salvage a bit more. So that's ongoing. The other case where it has attracted quite a bit of publicity as well is Getty Images against Stability AI. The parallel proceedings have been brought in both US and UK for Stability AI misusing more than 12 million Getty photos. So the case goes. And also there are evidence that suggests that even the watermark of Getty Images reappear, albeit a bit fuzzy and on the output photos. So in UK, just a few weeks ago, there is a interlocutory decision on application brought by Stability AI for summary judgment to dismiss the case on the basis that the model in issue was developed entirely outside UK. And then also for an application to strike out Getty Images claim on the basis that legally there's no case. So Stability AI's challenge has failed. So the judge says that it's premature to decide the case. Certainly they need to wait for discovery and to see the witnesses in person. I've read the decision, and I can see some damage done to Stability AI insofar as the negative comments made by the judge on the inconsistent evidence put forward by the CEO of Stability AI. But anyway, we shall see. That case continues. Apparently, at this stage, there is no settlement in sight, so we shall see. And the next case, which is started at the end of last year, so just a few weeks ago, probably in the news, and most of you are aware of this one, New York Times against Microsoft and OpenAI for misuse of New York Times publications articles. Apparently, New York Times was very smart enough to design prompts that can elicit actually a lot of times, entire exact article to be generated by OpenAI of their own article. So New York Times says you must have uploaded their publications because otherwise you wouldn't have been able to generate identical articles. So that's really smart of them. So that's their decision. If the judge should find in favor of New York Times, that would mean that OpenAI will have to withdraw and remove all of the New York Times articles from their data sets. So that's a tall order, and that will certainly affect the operation of OpenAI. It is of interesting note is the position of OpenAI in their defense. They simply say that it is very impossible, quite impossible, to train AI models without using copyrighted materials. But if so, is this the case? If so, is this the justification? So they're saying, a lot of the people arguing in favor of the developers saying, look, if you only allow us to use materials that is already in the public domain, that doesn't require any license, it will end up with very stale materials, maybe 70, 80 years ago when all the copyright has already expired. So is this something that we want? It's interesting. This case is ongoing. It will definitely affect how OpenAI do their business. So we are looking forward to hearing more. Now let's look at this pretty girl. I like this photo. I'm going to put a big poster in my reception. This is the first text-to-image generative AI case in China. And I have put up a timeline on this slide, which I think is quite interesting, because as you can see, the work itself was purportedly created by the plaintiff only on 24 February. So he created the work, he uploaded it, and within less than 10 days, the defendant, a lady by the last name Liu, and she published an article on a social platform, and then she just copied and put this photo up whilst removing the watermark of the little red book. So it's less than 10 days, and then proceedings followed, and the Beijing Internet Court accepted the case for filing on the 25th of May. And then the trial took place within 3 months afterwards. So how speedy it is, how amazing when we look at the cases in US and other places, including Hong Kong, to be fair and honest. It took quite a few years for a case from start to finish, to the trial of first instance. So in this case, the court found infringement, and the court ordered the defendant to pay damages of 500 yuan, which amounts to $70 US. We never bring cases with a view to earning $70 by way of damages. And what's more, the plaintiff waived his entitlement to damages. So it's quite funny. So maybe he just wants a decision to test out whether AI work generated by AI will be protected. So effectively, so let's look at what the court found. The judge, a lady judge, she found that generative AI models cannot be the author of the work. And she took the view that the image was a fruit of intellectual input, which fulfilled the requirement for originality or independent creativeness. And then she found this to be an artistic work, which should be protected as a work by the copyright law. So that's what she found. And there's a little bit more about it, because the judge went about to explain the rationale of her reasoning. But then the point to note is, unlike the UK-US system, there is no discovery, nowhere near the extent in the UK or Hong Kong, not to mention US, which is really extensive. So it's just a case where the plaintiff went to the court saying, these are the prompts that I've entered, these are the parameters. I look at the first output, and then I introduce and gave further prompts, further parameters, and then I have a refined output, and that's the work. That's it. And then the judge said that she considered the generative AI model to be a tool only. And then there is no challenge whatsoever on the legitimacy of the underlying data sets used by Stable Diffusion. But I mean, I need to mention, people forget, what are the prompts made? It's like the author wants, well, I call him the author, but the author wants a Japanese girl, a young girl, in a certain outfit, with a certain hairstyling, with the sun shining from one side of her back, and then with the head or face tilted at a certain angle, etc. And that's all the prompts. So, and based on these prompts, the judge found that the image qualified as an artistic work. Are there any aesthetic decisions? And then, as the work is generated by all these words, text to image by definition, so is the work actually a literary work of the prompts? Or is it an artistic work of the image? And is the plaintiff Lee independent or creative? And these are questions, but the court has answered, of course, they're all in the affirmative. So, but in so doing, is the court encouraging or stifling creativity? The judge, she actually said that, she said we have to encourage creativity. So, and that's why she says that if I am to dismiss the case, then people will be disenchanted, discouraged from creating. And so that's why she wants to encourage them. But it remains to be seen if there should be a case big enough to challenge all the various issues I mentioned about the input, output, and defense or exemptions or whatever. to see whether and how whether generative AI can stand to qualify for copyright work. And then I promised to mention about the defenses, which I say is fragmented internationally. In the US, we have a long-established fair use doctrine comprising these 4 factors: purpose, character of use, nature of the work, amount and substantiality, and the effect of use on potential market. So whether it is sort of to the detriment of the copyright owner that you're using the work in the way that you are using. And then the court will look at whether there has been any transformative use that is not contemplated by the initial copyright owner. So the most notable case, of course, is the Google case, where that took 10 years to go all the way to the Supreme Court. In the end, what happened was Google was scanning and uploading a lot of books and articles written by members of Authors Guild, and they say that we are not reproducing it and lock stock when everyone search for it. They catalog these books to allow users of Google to search. Not the entire book. They won't release the entire book on the prompt of a search prompt, but they just allow you to search. And the court finds that this is for general benefit of the society. So they say this is fair use. This is the US. Okay, so that's unique in US. It has its benefits. In UK, EU, and Hong Kong, copyright exceptions are codified. They set out those areas that you are allowed to use someone's copyright work. If it's not there, you can't use it. Okay, so the flexibility in an open-ended copyright defense is arguably beneficial because it accounts for technological developments as they come. So we don't have to change law every time something comes up. You can apply it to the VCR, we can apply it to Google, and now we can apply it to AI. So we can use the same law. So the rationale is good. Say that you need a lot of litigation to determine whether on each new technological development, whether such development qualifies as fair use. But then, of course, it ensures the law keeps up with societal progression. So effectively, the legislature thinks that we should leave it to the court to set the rules. And as you've seen, as I've mentioned, courts have explicitly found fair use in multiple instances, starting from the VCR case, and then we have the Google case. So they all qualify as fair use. Now, on to text and data mining. The exceptions to text and data mining is usually the permitted acts of defense available in jurisdictions like the EU, UK, Hong Kong, and a few places, Singapore, etc. So what is text and data mining? Also known as I put it, not me, but everyone puts it, is scraping the internet. Basically, you use tools, software to crawl the internet, not the entire internet, of course, but the best part of it, and the use of automated analytical techniques to analyze text and data for patterns, trends, and other useful information. And then analysis is usually facilitated by the copying of copyrighted content, a lot of times without the consent of the copyright owner. It is essential, of course, to the general development of the generative AI industry, as generative AI programs produce outputs but purely rely on the information provided to them. So, so this is how this is done. And I would like to illustrate what TDM is by my own AI-generated output. I won't assert copyright on this, but I did give the prompt to generate this image. And the three words that I use to generate this image is simply scrape the internet. I find it very good in that you can see the scraping effect, the impact, that all the dust and all the concrete being being scraped to the core, or as we always like to say, scraping the barrel. And now it's in the wilderness where basically you're scraping down the bare bottom. So should this be allowed? Let's see. So let's look at the various positions in different jurisdictions. So you can see this is the international perspective here. UK, they allow TDM purpose for non-commercial research only, and even for non-commercial research, there's an argument as to, okay, what is non-commercial research? Can you start non-commercial and then and then you spin off and do a startup, and then try to make money after it? So is this research laundering or data laundering or whatever you call it, or copyright work laundering that you can call it? So this is the concept. So this is very controversial. There's always argument and how useful it is to allow non-commercial research only. It doesn't really help. And in the UK, they are now trying to introduce a code of practice to allow the stakeholders to get together to decide for themselves as to whether there is a suitable model. I mean, suitable model, I don't know how this can be done, but of course, if you look at Spotify, I think that's a good example where they're using copyrighted music by paying. It's doable, but of course, we are only assuming that you can approach big music labels. But for individual works, that may be difficult. In EU, they also have scientific research. And then because they have an interesting opt-out provision for right holders not to allow TDM, and how this can be done, I don't know, honestly. Japan is pretty generous. They basically allow TDM. And then the Hong Kong, Singapore, once again, also fairly generous. And then in Hong Kong, we haven't done anything as yet. We have no TDM exceptions. Our chief executive has promised to commence consultation as to how to enhance our copyright ordinance for the protection of AI technology. So I eagerly await the beginning consultation as to what can come about. But so that's it for now. And with this, I think that brings to an end to my presentation. And of course, I welcome any questions that you may have.
All righty, let me get centered here. So thank you so much for your time. I really appreciate it. I'm gonna jump into the Q&A, but I just wanted to again thank you. I know it's late out there, and I really appreciate it. So I'm gonna post. As we were talking, I started some of the comments that were showing up on this Yard stream, or StreamYard rather. The first question, if we can answer it, or you can give your thoughts. It says, "How does AI get used on a workspace? Are the risk of AI being disclosed in public spaces platform?" And I guess this might be a comment to, I created an AI platform. We're using workstations, and basically all we're doing is, I'll give you an example. William Shakespeare, it's public domain, and we took all of his literary works and we put it into our own AI, and now we create that workstation where you can have a conversation. And so, in my opinion, this is public domain information. We're not using anything that you can't do yourself. And in my opinion, that would be something that's feasible. Someone else just posted. Go ahead. Yes, sir. You were going to say something?
Yeah. Allow me. Don't miss out on Harvey's. You just talked about the Shakespeare thing. I've read your post on this one. I'm really interested. I know hardly anything about Shakespeare, but I loved it. The idea that you're using it and you're trying to educate the public who is interested to learn more about it. But you're quite right. It is in the public domain. And on the corollary, I want to suggest that one possibility, but only for big corporations, is to develop their own private domain generative AI system models using your own database, so that there will be no issue of leaking of anything to the public. But of course, obviously, you need a huge database. So maybe, for example, in one single hospital or whatever, your own patients, then maybe that's doable. So that's the thing. Because I did, even for the small size of my firm, I did commission AI developed to look at whether they can use my own personal data, firm's data, and templates to work on some private domain search engine for me to work on. So these are something just worth thinking.
Yeah, and since you mentioned it, I'll go there. There's a thing called New York Tron, and there's a thing called Gatortron, and those are two databases that the New York Tron is from New York, the Gatortron's from Florida. But the skinny is this: they're using all the patient information from in-house, all their personal servers, not outside. And then they had patients sign that that's okay to use. And now they develop their own AI with predictive analytics inside. And I agree. I think that'd be a great use in healthcare. The next question here says, from Paul, thank you. It says, employees keep asking for more guidance for what can be uploaded. If a sales rep removes the pricing and customer specific info, can she use ChatGPT to refine the proposal? What if the product manager uses customer data, but then asks ChatGPT to refine the business strategy? So what do you think?
Well, I think number one, the employers is imperative on the employer to set definitive, easy to follow use policy, as I've earlier mentioned in my slide. So that's important with training, of course, to tell them what can do and cannot be done. And then secondly, insofar as these pricing customer specific info is concerned, these are probably confidential information of customer. Once you upload it in ChatGPT to refine the proposal, it will go into the public domain. It can be used by ChatGPT for other users. So that's a huge risk there. But of course, this guest also mentioned about using maintaining anonymity on the customer data. That's possible, of course, long as the public or the relevant consumer, whoever in the same industry, won't be able to identify and associate such information with that particular customer. I think that's okay. It really depends on how small the industry concern is, of course. That's possible way.
Yeah, good question. And just to let you know, I'm not self-promoting here on this, but that Shakespeare principle that I was sharing with you, that is what we're already doing with some attorneys and some private companies. We're creating a private server, our own AI, and then letting them to upload their own information, and that information stays within the company.
Lovely, lovely. I like that.
So the next one, it says, reasonable use and training for foundational platforms in patient spaces like EMR is insightful for remote monitoring and decentralized service. I just took some from people that were during your talk. This is a good one. Can a prompt be copyrighted?
Yes, I can say can, because it can, but may not be always, because prompt itself can be a very specific and specialized discipline. We have prompt engineering these days, where people teaching user how to use prompts. So it depends, of course. If I only say scrape the internet, I won't assert any copyright on a prompt. But it can, because prompts can be really, really complicated. I'm sure you know, of course, Harvey, I mean, you specialists here. I've talked to the academia or academics, and they write really complicated prompts, which leads me to think that copyright can subsist. Although the question is, how can you determine whether a prompt, if there should be copyright? How can you determine whether a prompt has been infringed? Because all you can see is the end product, is the output. You won't be able to know what the prompt is. And the same prompt can generate different output at different point in time, or maybe using the same machine. So that's the challenging bit on the evidential burden. But per se, I think it can subsist in copyright in prompts.
No, that's good to know. Honestly, I didn't know that one. I thought it couldn't. Just to give you a background, I do a lot of prompting, and I've created plugins, and one is called Decision Matrix, and the skinny is this. I took all these years of like getting my MBA. There's certain principles of, the 80-20 rule, or, Oscar's razor, or different things. But what I did is I created different prompts. So when you ask any question to make a decision, it goes through a decision tree. And now that I hear this, I could probably copyright that. And it gives amazing output, which most people like, how are you getting these results? And honestly, it's just the background prompting. So I didn't know that. So thank you. The next one is how will we basically how can validity be confirmed in AI? It's more of a technical question.
It's sort of a freedom to use, freedom to operate. Validity, I mean, whether it's free to use, whatever. If that's the question, then I would say it's very difficult, because who's going to tell you that, okay, this is safe to use? All you can bank on is the indemnities that you can seek from the service provider or the developer, as I've mentioned, Copilot, whatever. So because it is too much of a burden to expect a user to know how valid or how useful it is.
Yeah. The next one, thank you. Can AI be used reliability for prelim, patent feasibility, and research?
How can I answer this? Because you say whether it's used reliably.
Yeah,
Never, because there's hallucinations there. It's always that. So,
exactly.
but it's a good part.
Exactly.
I think it's step one. I think I would use it for step one, without, of course, sacrificing the novelty of the invention. I mean, and that has to be sure. I
Yeah, and I'm gonna answer this on the geeky side of me. You could do RAG training and think of it this way. If I was able to get all the patent PDF information and upload it to my own server, and then when you ask a question, and as long as I kept it up to date, then it would hit that database first, and it would less likely to hallucinate, depending on the
mean,
prompting and how it's an engineer. Now, with that said, it still may hallucinate in maybe 3-4%, and that's always going to be an issue for now. So that's just my 2 cents.
I need to add this. There aren't very many Harvey Castro out there. So yes, I think that's the best you can get.
Well, I appreciate that. The next one is, how are risks escalated and rectified in personal and professional spaces? Does IT play a key role?
Well, definitely, because that's why I say it's important to have a mechanism in place where high risk can be identified and escalated to people having oversight of such risk and to solve it. But how can this be done? I mean, it's difficult, I have to say. But that's why the manuals, the acceptable use policy is important here. So that anything that goes beyond the acceptable use policy or terms and conditions, that will be flagged. I think that's important.
Correct. Jason asked, great presentation. Will this presentation be recorded? And the answer is yes, it's being recorded here. So you'll feel free to share this stream, everybody. And then I'm also currently transmitting this in live to YouTube, Instagram, Twitter, and Facebook. So it'll be all on my account. I had another question. Oh, yeah, that was just me stating. And then Jason, again, he says, I'm the president of Transformation Lights, which provides an AI-powered complex program management technology to the market. Our AI and focus are internal today, but we intend to expand to accept OpenAI to the product at the request of our clients. Am I correct in assuming the risk is the clients?
This is what you can say in the terms and conditions of use here. But of course, they can always say that there's an implied term in your service. There should be what we call the is implied term that we will not be exposed to litigation. So quiet enjoyment, yes, the principle of quiet enjoyment. So I buy something from you, I can safely assume that no one will be bothering me. So it really depends. It depends on your bargaining power, obviously. And and then of course, because the data set is being uploaded and provided by the service provider, developer in this case, then of course the end user, they can't determine, as one has asked, whether it's safe or valid to use your stuff. So it really depends on the terms and conditions and subject to any consumer protection laws as to whether any such disclaimers are enforceable or valid in law. And of course, it is important for the developer to introduce such limitations.
Yeah, thank you. And this is just a comment from your presentation, the risk of human error. And I agree. At the end of the day, we're humans, and when we're programming, when we're putting things into AI, our inherent biases will end up in the model. And ironically, I almost feel like we need another AI to evaluate, to find those discrepancies and see how we can mitigate that discrepancies, which is interesting. I had a quick question that says, and this was my question actually, what if a public-facing website shares information and a company uses that information and asks as part of their AI use, similar to Google, would this be considered fair use? For example, if I go to any website and they're talking about X, and then to your term, we scrape that data, put it into our AI, and now our AI is able to go and find that information because it's the same question. Would that be considered, and I know that's a kind of dicey question, would that be considered infringement?
I liken that scenario to the defamation law, where even if you are relaying or sort of copying certain untruthful, wrong, defamatory statements, you are still accountable as being. So, in that sense, okay, all very well. You say that you are just sort of scraping from somewhere else, but that doesn't give you sort of a blanket immunity against any claims for false information, whatever. So I don't think fair use works here. But obviously, I'm not an American attorney, but I don't think it works. As you say, I mean, isn't it?
Yeah.
I see.
My angle back, my counter argument would be this is generative AI, and it's taking part of that information and it's not really copying it, and it's saying, hey, this is, or it's paraphrasing. And then obviously it would give a reference and say this is where it was taken from. So we'll see.
That's an excellent point, Harvey. I mean, so as we say, caveat emptor, let the buyer beware. So I'm just telling you, cards on table. This is where the information come from.
Yeah, no, that's good. Thank you. Noreen basically said, I lost the connection, but this is superb, Ty. Thank you. You have done a wonderful job over the past year, brings AI gifts and opportunities to the public, but also wise discernment and lesson learned as AI goes forward. Have a great day, everyone. Super knowledgeable, humble speaker. And thank you. And then it's another one. Thank you so much for your insightful. And I just learned about AI, and I believe today's session will be really helpful for me. So thank you for joining. The next one, I have a concern. We get detailed sessions on the issue of employment because of AI. How can anyone who are scared and laid off because of AI can build their career in today's AI world? And it's honestly, it's a good point. Big picture, I just posted last week about how important it is to have a digital signature, because as employers start looking at your social media and your presence, that might be a role in that they may need you as an influencer, or they may need to know exactly about your social digital footprint. And what I'm getting at is, I see a lot of this getting automated, where AI says, okay, this person has this many followers, this many likes, and I think it's going to make a role in your employment.
Yeah. I don't have any endorsement, but I certainly recommend you watch Coded Bytes. It really talks about a lot of these situations.
Okay, good. If you don't mind later, if you drop the link on the comments here, and then I'm sure everybody wants to watch it. And
Yes.
so the next one is thank you. And then I think this is maybe the last question. It says, if you have your own GPT built on an open source platform, no web access, can that be copyrighted and or confidential?
It says no web access. So in that sense, I take it to mean confidential. But I don't know what is meant by open source. If this is what I think it means, then you probably don't own copyright, because what you're using is someone's work, or it's either in the public domain or whatever. So whether copyright can subsist or whatever, that really depends on what you've used.
Yeah. No, that's a good question. That's a good point. And I just went through the comments. We had one last one just jump in. It said, you mentioned IP concerns. What are your thoughts about leveraging generative AI to protect your IP from theft?
Very interesting. To leverage generative AI to protect our IP from theft. But generative AI per se, the arguments these days is they are the thief. So they are taking work from the internet. So how do we use it the other way around to guard against theft? Of course, I mean, for example, like the another case, the Turnitin, the against plagiarism, where you use AI or whatever, and you upload certain articles, and then based on the database available, then the machine will tell you AI whether this is a copy, whether that's plagiarism. So in a way, that's theft from IP. And then you can use generative AI to look for similar, what we call prior art, so similar products, to see whether this has originality. So that can help as well. So in that sense, that's leveraging generative AI to protect your IP as well. So it depends on the database. And as you say, you can say download the entire Google pattern search onto your private database to do your own search. That's possible.
Yeah. All right. Well, I really thank you. I know it's late out there. I'm going to end the show, but I would love to have you back whenever you have time. I know AI changes so quickly and so fast, and so many laws. And I know the GDPR and Europe has all these new updates. And then those are always evolving. So I'd love to have you again. But thank you so much for your time. I'm honored that you're here. I'm glad we met. And do you have any final thoughts, or how people can follow you?
Yeah, it's such a great privilege to be talking with the blue badge, the IP top, the LinkedIn top voice here. I'm always available. I'm just a humble lawyer, so I'm there, whenever you need me. So I'll be around. But I hope everyone has something to take home. It's a very interesting, ever evolving, as you say, topic, rapidly evolving as well. So keeps on changing. Last time when we met, you were kind enough to say you don't need to update your PowerPoint. You can use the same PowerPoint, but I just can't use the same PowerPoint. It's 10 weeks down the road, and I've discovered I cannot use the same PowerPoint. So, but I look forward to talking again in no time, and whatever topic that anyone will be interested about AI, I'll be here.
Awesome. All right. Well, thank you. Let me end the show, and then you and I can chat. I'm going to just throw this up. Thank you, everyone. And please follow him. He's on LinkedIn, and a great, amazing person. And if you need an amazing lawyer, there's one that's right there. So thank you, everybody.